Sisi ano inti se ensem no back to back. Ti se do obi bo nyinim no. Tsikata enso akwakopi mu e Supreme Court. Na okopi mu e Supreme Court no, ebusuafo come and see for your eyes. Babeshema wani. Tsikata say Torkono and Afenyo ye do betina hot seat so. The case of atofo sina ububu fire so one Attorney General AG Odami ebubu fire so eka bibu ma ye hu ya ho ano afi na ye kra no court ba enye ye de no Afenyo yenso ye betrel pa ye betrel no ko pepe ebe mo wadua mo ko de onsa we ebesi wo no wapejo na ba kwa hwiri me ho na be hu say yes nyame eyodo this time around Chief Justice Torkono Tsikata say remember for say this time around Cynthia Mamley Morrison so wumpo or MPP new so NDC new and not the amount found but was a Cynthia Mamley Morrison echo as independent candidate obeko so umpo Cynthia I was say oko as independent candidate ewa Aguna West and who say yes MPP for me say yes nyame wo hoi oyodo na nyame onye kwatani come hoi na yekweti nsema ye Tsikata edituja but before that no subscribe to Ordinary TV, like and comment your comment section so click on the notification button for more news updates and channel on Yekweti Marcisia
and their comments are not exciting, their comments are not pleasing. For example, a former Chief Justice has publicly declared that our judiciary, especially the Supreme Court, is becoming too predictable. What does that mean? How do you predict the outcome of cases before the judiciary, before the court? And what makes them so predictable? Orientation of judges, known commitments of judges, their records and so on, is what makes it predictable. Now, if this is what judgments are based on and so on, then this country is in very deep trouble. Then I heard this eminent lawyer, Mr. Tsikata. And Mr. Tsikata says very clearly that the crisis in our judiciary is far worse than the crisis in our economy. What? That's a huge statement. As if you're talking about the crisis in our economy, you're talking about bankruptcy. You're talking about a country which needs more than 128% of its total national revenue to service debt, pay debts, and pay public sector emoluments. Now, if this crisis is less weightier than the crisis in the judiciary, then we have a monumental crisis in the judiciary. And these are not my words. These are the words of somebody who has been a law lecturer for many years, and who probably was a teacher of some of the people who are sitting on the Supreme Court today. And his verdict is that the crisis in our judiciary is far worse than the crisis in our economy. Now, I watched the proceedings yesterday. You understand? I watched the proceedings yesterday. And I've also read the report of which you read from one of the newspapers, which says that the Chief Justice was angry. You know, I mean, where does anger arise in the work of the Chief Justice? The Chief Justice's role is to impartially, with other judges of the Supreme Court, interpret the Constitution. Where is anger in that? How does anger arise? How does anger become an issue? So I'm just sitting back and wondering, I mean, where is this anger coming from? Okay. Now, I want today just to dwell on principles. Okay? Just to dwell on principles. Ghana has a Supreme Court only because 32 million Ghanaians cannot sit in judgment over cases. Ghana has a Supreme Court because 32 million Ghanaians cannot sit together to interpret the Constitution. So that power of the people, the power, the sovereignty of the people, has through legal arrangements, including constitutional provisions, been transferred to some category of citizens. So when the Supreme Court actually sits, it sits in the name of the people of Ghana. The Supreme Court itself doesn't have any powers beyond the powers that the people of Ghana have vested in the Supreme Court. So at every time when the Supreme Court is making decisions, it should be asking the important question whether it is truly, genuinely, legitimately acting on behalf of the 32 million people of Ghana. That's the test. So at any time when the Supreme Court acts against the expressed, unexpressed will of the people, the Supreme Court's essence, the essence of the Supreme Court is lost. And we have to understand that very clearly. There's a matter of principle. Okay. Now, the Supreme Court interprets laws, including laws enshrined in the Constitution and so on. Eminent jurists have established a principle of law. And that principle of law is referred to as the purposive interpretation of law. Purposive. And this is a principle which is known by every law lecturer, every law student, every law practitioner. Now, what does the principle mean? That principle simply means that in interpreting the law, the general good of society should be taken into account. So at every time that the Supreme Court sits to adjudicate on any matter, it ought to be asking itself whether indeed that interpretation of the law contributes to the achievement of the general good of society. This is an important principle in law. I'm not the one who is coming up with this principle. Now, there's something else which is absolutely important. The general principle is that the Supreme Court expresses the sovereign will of our people and so on. It has to. Okay. But that sovereign will of our people and so on is embedded in the Constitution which the people of this country adopted for themselves in 1992. Okay. Now, at every time, these judges on the Supreme Court and the Court of Appeal and High Court and so on should be asking themselves very important questions. Ghanaian people lost their lives in order to give life to this Constitution. Ghanaian people suffered imprisonment and so on, clear hardships in order to bring this Constitution into being. Now the question I pose today is whether or not the conduct of judges takes account of the huge sacrifices that the people of Ghana made in order to bring about this Constitution, which makes it possible for us to operate a Supreme Court and which makes it possible for us to appoint a Chief Justice and Justices of the Supreme Court. The people who struggle for this Constitution, to give life to this Constitution, is this the outcome they wanted? Do they want an outcome such as this one and so on? You understand? Now all these are matters of principles which I suspect are not challengeable. These are principles which the legal practice, judicial practice and so on have established over the years, and I think it's important to apply them at all times. Now yesterday, after reading the judgment of the 5 justices, I heard the Chief Justice in a very angry mood pose the question, why have we come to this? Why is Parliament not sitting and so on? Is that the business of the Chief Justice? whether or not Parliament should be in session or not is clearly the duty of the Speaker. The Speaker calls Parliament into session. The Speaker is the one who adjourns Parliament, definitely or indefinitely, and so on. What has that got to do with the Chief Justice? In any case, why was Parliament adjourned? Parliament was adjourned because it didn't have the numbers to take decisions. It is not because of the Speaker's decision. It is not because of the injunction which was being sought in court and so on. Parliament simply could not have the numbers to take decisions, and that's why Parliament was adjourned. Is the Chief Justice in any way suggesting that Parliament should sit when it doesn't have the quorum to take decisions? Is that what the Chief Justice is suggesting? And if that is not what she's suggesting, and she's acting in her capacity as a citizen rather than a Chief Justice, and she's entitled to that, perhaps what she ought to do is to advise members of Parliament of the New Patriotic Party not to boycott parliamentary procedures. In order that we shall have the numbers to do business. That's all. And she can do that in her capacity as a citizen. That does not lie in the mouth or actions of the Chief Justice, but it lies in the mouth and actions of any and every citizen. And the Chief Justice indeed has a right as a citizen to make appeals to members of Parliament not to unduly and unreasonably, boycott parliamentary procedures so that we can get business done. And I have no quarrel with that. Now, one of the issues which came up yesterday was the claim that the Speaker's lawyers had not filed their responses to the matter